Today's not about headlines. It's about the fine print. Two bills passed, well, not so quietly, that could change how schools handle gender, discipline, and your role as a parent. So let's talk about House Bill 1296 and Senate Bill 5181, what they really do, what they don't, and why it matters. And welcome to the Evergreen Report. So to start this off, there's a lot of controversy going around House Bill 1296, Senate Bill 5181. Coupling those, there's a lot of misleading headlines. And I want to be the one person that, yes, I'm a conservative. Yes, I'm a Republican. Yes, I believe these bills are still bad. Just to preface all this. But I think there's some things that we need to clear up. There are some things that we need to get straight. And I think there's some things that the public has been misguided on just to invoke some of that emotion. And if you have common sense, then you are able to sift through some of these headlines. You're able to sift through and say, that doesn't sound right. And, I put these 2 bills through a fact check. I downloaded them. I read through them. Did I understand them? No. Did I go to my favorite AI? Yep. I went to ChatGPT. I went to Grok. And they both gave me very similar answers to the claims that are going around X, Facebook, that are very misleading. While some are true, they are very misleading. And I wanted to be the one person on the internet talking about it. So let's do so. Before I do that, though, I want to jump into Zip It and Vote that went out in Olympia. So on Monday, April 14th, House Democrats in Washington invoked a rarely used rule, moved the previous question to shut down debate on the Parents' Bill of Rights, Senate Bill 5181, especially an amendment removing the emergency clause. This cut off all discussion and went straight to vote. It happened twice in one night. So what does this even mean? Well, the reason they wanted the emergency clause done is because what is done with an emergency clause, what is signed into law with an emergency clause, cannot be undone through the referendum and initiative process. So it's one of those tricks they use, and the more we get into the Evergreen Report, the more we're learning about this, and the more we're learning that this is clearly not okay. They put the emergency clause on a lot of bills when it's not an emergency whatsoever. So why does this matter? Well, tradition was broken. This shattered a 132-year norm of requiring a two-thirds supermajority to end floor debate. As of January, Democrats changed that to a simple majority of 54-33, making it possible to end debate without a single Republican vote. This, of course, has free speech concerns. First Amendment rights. You're entitled to debate. You're entitled to freedom of speech. Our Constitution depends on it. Republicans called it a legislative red card, comparing it to being ejected from the game. Critics say it muzzles minority voices and sets a dangerous precedent for debate in the legislature. Because if Democrats can pull this any time, sit down, shut up, and vote. Isn't that weird? Doesn't that raise some red flags? What are they trying to do? Why are they trying to do it? And so I want to bring that up here, as several Democrats spoke up on this. Representative Monica Stonier, Democrat, called for motion, clearly fed up with the GOP pushback. So she called for this motion. Said, hey, I'm fed up with this. I'm tired of all these Democrats. You guys need to stop, shut up, vote. We're going to pass this along. Anyway, it doesn't matter. I don't care. We're going to do this what we want. Representative Jamie Dufault, Republican, tried to talk about the motion afterwards. Speaker Lori Jenkins cut him off and told him to stay on topic. Again, that's what typically happens in these debates. If you've ever watched them, heard about them, watch highlights of this, they will quickly move off the Democratic plate, shut them down, and it will not matter what the Republicans have to say in the House here in Washington State when it comes to any of these votes in the House or in the Senate. Final speech was given by Representative Jim Walsh, Republican, and Representative Christy Reeves, and Jim Walsh absolutely crushed it. But regardless, this bill passed 57-38, along strict party lines. So it's a controversial bill, loaded with an emergency clause that prevents a referendum by voters. The GOP wanted to remove that clause to allow the public a say. Them shut it down. So this isn't just about one bill. It's about so much more than these two bills themselves. Access to debate versus the efficiency of government. Majority rule versus minority right. Process integrity versus political control. And this sets a dangerous, dangerous, dangerous precedent here in Washington State. Expect more debate to be cut short in the future. Because if they got away with it, they did this one time, oh, we can do whatever we want, and we'll get away with it. It doesn't matter what they say. Who cares? We don't even have to listen to them. Let's cut it out. We're going to vote this thing past anyway. Let's move it through. Same happened with House Bill 50 or Senate Bill 5041. Same with House Bill 1163. Same with House Bill 1296. No matter what the Republicans say, they're just going to vote no on it anyways. And so let's just shut up and have you save your breath. Is what I'm taking the Democrats are saying here. So the emergency clause tactic keeps controversial laws off the ballot, which is a problem, right? Because we, the people, have a voice. You, the person, has a voice. We all have a voice. You, me, your brother, your sister, aunt, uncle, we all have a voice. Every voting person in Washington State has a voice. You're entitled to that voice. We're allowed to challenge these things and get initiatives. and make changes. First and foremost, that's kind of our opening here, what we're doing there. I have created a whole Q&A on a Q&A one pager on the policy comparing House Bill 1296, 5181 to the current initiative 2081. So you can kind of see what changes, what stayed. We're going to answer all those things right now. So first off, what changed, what stayed? So what stays the same? Parental rights are still intact. There are still parental rights intact. There's a lot of claims out there. There's a lot of false information. We'll go through those here in a second. But what is staying? You still have access to all your students' records, every single last one of them. You can still review curriculum and opt out of sex ed and surveys. You must still be notified if your child is involved in a crime or questioned by police. And you can still file complaints if schools violate this policy. So, what was removed? Well, I think this is really important to know. Advanced notification for non-emergency medical services is no longer required. So all those rumors about kids being able to get care of different kinds in school, not emergency related, is true. There's no reason for them to call you, tell you that they are getting these cares and whatnot. Follow-up notifications, crutches, emotional recovery care, they were also removed. Notifications that trigger insurance copays, also gone. The right to sue if your rights are violated, removed. You now have to go through the OSPI and Chris Richtel's office. They're not going to listen. They're not going to care. They're getting what they want. They're getting exactly what they want. But they also attached an emergency clause onto this, and I just want you to ask why? Why do they need an emergency clause on this so bad? It's so interesting. If we were to break this down further, let's get into a technical breakdown. So I want to break these down in a technical sense for you guys. And honestly, I'm a little afraid to put this episode out, publish it, talk about it, because I know I'm going to get some flack from both sides saying that's not true, that's not true. And this is strictly based on research. This is strictly based on fact checking, reading, and my interpretation of these things, of course. So if I'm wrong, please correct me and whatnot. First and foremost, the technical breakdown. What these bills do, they align state law with Initiative 2081, the Parents' Bill of Rights. They replace transgender student policy language with broader gender inclusive terms. They give OSPI more power to enforce compliance, including penalties, which they won't. They require school staff training on gender inclusion, which they won't pay for or fund. And they create a formal OSPI complaint process for families, whether that's for those who are upholding the policy, not upholding a policy, or pushing it too far. That line is there. OSPI now is given way more power than they should have through these bills. And I think that's the biggest takeaway here that we're not really talking about. We're not really talking about, the different things, boys using girls' bathrooms, all those kind of things, because those things are still there. Those things are still in place. Nothing changed in that aspect, but we're going to get to that in a minute. OSPI now has the power where they can investigate school districts for non-compliance. So if they're not complying with these two bills, 1296, 5181, all these referendums, these changes, things like that, that gave them unchecked power, in my opinion, they can investigate for non-compliance. So a district like Kennewick here in the Tri-Cities, Tumwater, they can be investigated by the OSPI office, and then they can withhold up to 20% of basic education funds. Who does that hurt? It hurts the student, hurts your kids, hurts my kids, hurts all of our kids. That's what it comes down to. They can initiate action against superintendents and school board members, as in they can file to have them remove and install their own people into it, is what I'm getting from that. Parents and community members, not just students, can now file complaints. So even advocacy groups, big groups that want to essentially take down a school, maybe a school board member, maybe a superintendent, for maybe saying the wrong thing, supporting the wrong thing, which may be the right thing and does all as well. Community members who may not even have students in the school can now file these complaints and kind of play spy and play operative and run these takedown plays as they want, which is a really dangerous game to play. It's a very, very dangerous game to play, and it gives OSPI far too much power here, far too much power in all these terms. So let's also talk about when we're getting into the classroom. So we talked about the technicalities. Let's also talk about what that means in the classroom. The gender inclusion in the classroom, what it means in practice. So what these bills do not do. They do not create a new bathroom or shower access rules. That's already law via Title IX and RCW 2842, which allows for students to use the restroom and showers of their gender identity. So that didn't really change. It just aligns that language. So that's kind of where we're getting that headline from, that it's going to allow your 9-year-old boy to go into the girl's bathroom. Well, if your 9-year-old boy decides to go to school and identify as, if he's little Johnny, he's literally going to school identifying as little Jamie, and he can then use the girls' restroom and they can't stop him because that's already within state law. So nothing really changes there. There is nothing within this bill as far as I could find. I asked too many different AIs, Grok, ChatGPT, so GPT leans more left, Grok leans more right. both of them said the same thing. They do not allow hidden medical transitions, which is something that's another, attention grabbing headline. That's going to allow the school to transition your kids for you. However, they will be able to give them care, non-emergency medical care, which could, be a loophole against that, but it doesn't clearly directly say that in itself. And they do not override opt-out rights or curriculum review. So parents, you're still entitled to review curriculum. You're still entitled to opt your children out of curriculum that you feel you want to. I believe schools still do have to report these things, and doesn't change anything there. These bills do reinforce gender inclusive policies across all schools in the state, for better or for worse, which that does conflict directly with federal law to remove kind of all this DEI, gender inclusive language from schools. So we'll see kind of where that does. Make staff training mandatory, but it doesn't make it so that they have to. Well, there's students where they have to train, but where's the funding going to come from for all this training? Where's the curriculum going to come from for the training? Who's going to make it up? Who's going to run it? Who's going to deliver it? How's it going to be consistent across the board? This does also protect student privacy, meaning schools do not have to tell parents if a student changes pronouns or name, which is probably the most controversial element of all this, is privacy versus parental notification. Okay, so if my daughter goes to school and she's identifying as a little boy with a different name, the school does not have to tell me. And when they go home, they can say, okay, bye, so-and-so, and write her regular name. So I am left the fool, and I never know how these things are happening within the school, because they don't have to communicate with me in any way, shape, or form. I hope that schools still do communicate with this, and they do what's best here. And I feel like that's going to be a really key element, is what these individual schools and teachers do. So to reference a recent episode I did on the Evergreen local kind of KSD school board president, Gabe Galbraith, he was talking on behalf of himself personally, not on behalf of the school board. So he's his own personal opinions and whatnot. We have 95% of teachers who are really good. We have 95% of teachers are great, who will not follow these, who will communicate with the parents, that will, communicate these things, so on and so forth. We do have 5% that is working to push this extreme gender ideology. However, let's just say the school board superintendent office, they are working hard to make sure that 100% of teachers are all well aligned with the expectations, the rules, and kind of what the vision is for the school district as a whole. So speaking of controversial elements, let's jump into some common claims fact check. And these are fact checked across both multiple AI programs to see kind of what the truth is. So, and I invite you all to do this. Download the bills. Go to ledge.wa.gov. Download the bills. Take them over to your favorite AI program. Plug them in, ask it, fact check these claims, and go into it. Go and find that viral tweet from, what's his name here? The only reason I know this is because this tweet has gotten more attention than it should, even though it's misleading, and it's invoked that, emotional reaction from people, which is exactly what these things are meant to do. And they're meant to invoke that emotional reaction to get you thinking, not logically, to get you to ignore the facts, and to get people to fight and cause division. But let's look at facts. I want to look at facts, and we're looking at facts here today. Because facts are the most important thing that we can look at more than anything. More than anything, let's look at facts. Let's put on our critical thinking brains and think critically about these things and work through them. So this is by John Cameron at John Rock Holmes, off school campus. Not be notified if their child is sexually assaulted by a school employee. We're gonna get to that. Disallow parents to request their child's medical records. Disallow parents to receive graphic material before instructions. Disallow suspensions of repeat disruptive things. And I did put my comment on there, which wasn't replied to, wasn't liked by anyone, except for one person, where I put two of these on here that I said I read these bills. While some of this is slightly true, majority of this is misleading. And I would invite everyone to download the bills from ledge.wa.gov and plug them into both ChatGPT and Grok and do some fact checking. So one person like that, one person has some common sense, and they're actually doing some fact checking here. So first and foremost, let's talk about some common claims, and let's go through all those claims. We're gonna go through them one by one. And really just talk about them and what they mean. So schools can hide assaults. False. Schools must still report crimes and notify parents. Parents can access records. False. FERPA still applies. You can see all educational records. Students can leave campus alone. False. No provision allows 9-year-olds or others to self-excuse. Boys and girls bathroom. That is misleading. This policy predates these bills. It's based on existing and state federal law. You can't sue anyone. This is now true. Legal recourse replaced by OSPI complaint process. So there is no legal recourse for these things. There is an emergency clause which will prevent voter referendum. This is true. Going through more of those. Notification of medical service. This is now removed. Schools no longer must notify parents in advance when a non-emergency medical services are offered. This does not authorize secret medical care, but removes notification mandate. A follow-up care after school treatment, we covered that. No longer requires schools to notify parents of extended care arrangements post-treatment, a crutches med, emotional recovery. That could be puberty blockers, things like that. A notification of health insurance triggering events, remove the requirement to notify if services could affect copays or insurance. And I think that one's really shitty. 'Cause medical expenses are really big, they're really large. And just taking those out, that notification away from parents who are gonna have to pay this and fit the bill. School's not gonna fit the bill. That's what I want to see here. If the OSPI is gonna do all this, have all this power, the office of the OSPI office, Chris Recto office, you guys should be responsible for those dollars, not the parents, because you're the ones that took this away from them. Democrats, you guys should be responsible for this to fund this bill in full when those things happen. I might take their list of records parents could request. This is still allowed, but now simplified under federal FERPA definition. School must release all education records, but not have to itemize each type. So they're going to give you all the records, but it's just going to be kind of one hobble glop of documents, and they're not going to have to itemize them or organize them at all for you. They're just going to hand them to you and say, here you go, you wanted them. Good luck sorting through them. And you're not going to understand. They're going to be confusing. They're going to be misleading. The course can be redacted however the school pleases. That is one thing that is allowed. So yeah, really interesting. A public record access during abuse investigation is now restricted. If a parent is under criminal investigation or named in an abuse case, schools can withhold records unless court orders otherwise. So if a child simply says, well, I'm afraid my parents going to abuse me, something like that, they're going to withhold the record and not release those. Very simply there put, survey opt-out rights. Those are preserved but updated. Language now mirrors Federal Protection of People Rights Act, the PPRA, rather than listing every topic individually. It does take away those individual topics of this is what we're learning kind of thing. Here's a list. It mirrors that Federal Protection of People Rights Amendment. School removal notifications, shelters, host homes, preserved but softened. Language was changed to say schools can't remove kids without authorization, but it defers to existing law, which is RCW 13.32A.082, which already allowed a 72-hour delay in some shelter cases. Right to sue is now removed. It is all going to go through the OSPI complaint channels, which I think is terrible. Emergency clause is still present. Both bills take effect immediately and prevent referendum challenges. Critics say these avoid voter input, which it 100% does. It takes all that right to referendum away, which is a direct violation of your First Amendment rights. They're all over First Amendment rights. We're allowed to challenge our legislation. We're allowed to challenge things we don't agree with. Unfortunately, we have 5, 6 counties in the state that have more population in them, densely populated, than the rest of the state combined, and those are all blue areas. So just consider that it's going to take all of us red areas, all coming together, all of us parents in these areas to really fight back and to push back. Last one here, religious rights language. It was removed with specific reference. Older line about schools not discriminating against families' religious belief was deleted, but state federal civil rights laws still cover this. So kind of sad there that they kind of took the religious family out of this and not really care. What remains fully intact here, protected by Initiative 2081 and still in the law: access to all student records, rights to inspect curriculum and instructional materials, right to opt out of sex ed in certain surveys, notification of unexcused absences, right to file complaints on harassment and bullying, right to request special education services, right to academic performance record reports and meetings, right to be notified if a crime is committed against your child, right to be notified if your child is interrogated by police, and right to prevent unauthorized school removal. So these things are all in there. What it adds on, though, however, is the student rights statements require every school to publish and teach student rights, civil liberties, non-discrimination, due process, etc. Enforcement authority is now the OSPI, which is terrible. Rehabilitation, retaliation protections for teachers. Staff can't be punished for following the law, even if that upsets a district or parent, which is really sad because now teachers just have more opportunity to push these agendas onto your students, which is a really dangerous game to play, right? If they're following it or not following, or if they're going to the extreme with it, there's nothing you can do. You can't push back, which is really sad. And your only option in that case is to change schools, move schools, hopefully you get a better teacher, or homeschool, or go to a private religious school that may not be teaching those things because they're going to be exempt. Private schools will be exempt from these rules because they're private. They can do what they want. So something to think about there. District complaint process. Parents and students can now file formal complaints, not any legal action against anyone except for this complaint process through OSPI. And if they're actually gonna fight this, we will see. We will 100% see. So yeah, those are the claims, kind of exactly where they're at. Do you remember that? Let's see if there's any more details I want to share. Claim the 9-year-olds can excuse themselves on campus is false. There's no evidence of this. There's nothing that says that they can. There's no credible sources for this specific information. A claim parents must not be notified if their child doesn't appear in school or leave campus is false. They still have to report these things. This is an exaggerated claim, misinterprets the bill scope. allows boys to shower with girls. This is misleading. This is already covered under Title IX, WAC laws, RCWs. It still allows the same boys into the girls' private spaces, which is really wrong in itself. It goes directly against federal law, which is going to put Washington State funding at risk, but it goes directly against them and it doesn't specifically mandate policies allowing boys to shower with girls. However, if a young boy is claiming that he's a girl and that's how his gender identity, he is then allowed to into the girls' restroom, shower with girls, use bathroom there, things like that. OSPI can punish schools for noncompliance with state policies that violate federal law. This is unclear, really, partially false, but also partially true at the same time, because OSPI does have discretion here to discipline as they see fit. Parents must not be notified if a medical incident happened to their child at school. False. Does not eliminate the parental notification. It's still there. It's an exaggeration. Federal laws like FERPA and HIPAA also protect student privacy, limiting disclosures in specific cases, mental health counseling, but these predate House Bill 1296. So these are already in place, right? These things were already there. So I think that's something that's really important to know here. Early versions of House Bill 1296 proposed delaying notification for certain health-related decisions, student-initiated care. Amendments ensured immediate notification for serious incidents, including medical emergencies. Federal laws like that still are in play here. Parents must not be notified if a medical procedure happens that require insurance is false. I mean, this is true. They don't have to be notified of this anymore if it requires insurance, if it triggers a copay or anything like that. So they're gonna have to fit a large bill. Parents must not be notified if their child is assaulted off school campus. So this is partially true, but it's also misleading. So the two bills, House Bill 1296, Initiative 2081, they primarily address these incidents on school grounds during school activities. Neither explicitly mandates notification for off-campus assaults unless school personnel are involved or it occurs during a school-related event. So if it happens off campus, I mean, unfortunately, the school's not just. I mean, read it. Parents must not be notified if their child is assaulted off school campus. If your child is off school campus, something happens to them. Unfortunately, that's on local law enforcement and jurisdiction. It doesn't fall on the school. So I think you really need to understand kind of that claim there, what's going on. Parents must not be notified if their child is sexually assaulted by a school employee off campus. Democrats added an amendment that explicitly allows schools to hide this information. So this is false after some analysis. This is a serious accusation with no supporting evidence. House Bill 1296 does not contain provisions or amendments explicitly allowing schools to conceal sexual assault by employees on or off campus. However, it does protect teachers, though. There is more protections for teachers and educators for a variation of things. So does Washington law RCW 28A.32 requires schools to report suspected abuse or crimes by staff or to authorities. 2081 reinforces the immediate parental notification for crimes involving students. So this is still in place. This was not taken off air. There's no credible sources or no information found here. Disallow parents to request their child's medical records. False. You still can request them. It just has to be consistent with FERPA guidelines, HIPAA guidelines, or state guidelines as well. It clarifies that student privacy laws still apply, particularly for sensitive issues like mental health, reproductive care, but parents retain access unless restricted by existing law and emancipated minors. So you still have access under state law, and under federal, like you still have access to these things. Like that didn't change. Disallow parents to review graphic materials before instruction. So this is false, but also true at the same time. So this one's more misleading. Is more they just have to kind of tell you what's going in, but you still have the option to opt out, review it at your discretion as well. This allows suspension on repeat disruptive students. So this is also false. It does not address or prohibit suspensions for disruptive behavior. However, there was an amendment that did not pass during the debate for 1296 that would have created the Student Bill of Responsibilities or the Student List of Responsibilities or whatever it was. Pretty much what students agree to do, what they agree to be, pretty much agree to be good students, good kids. But that didn't pass. That didn't pass the House. It was close, but really should have. That would have been in great alignment with this bill, kind of what's going on here. So unfortunately, it doesn't allow for the suspension. It doesn't disallow for them either. Students still have the ultimate, or schools still have the responsibility to discipline as they see fit. And of course, there is an emergency clause which won't allow it for referendum. There is another claim that it unwinds the parent bill 2081. This is partially true. It does unwind and gut parts of it, but it adjusts language, it adjusts guidelines, it changes some things, but at the core, rights like accessing records, reviewing materials remain intact. So this is kind of an overstated claim, but there are things that it does unwind that it does undo. Another claim here: all three of the 28th district reps voted yes. Senator Tijuana Nobles, Representative Dan Bronsky, and Representative Matt Mari Levitt. So likely true. This is likely true for the House vote, but not for the Senate. So we're unsure how the Senate voted. Sure that we have that information at this point, but I'm not going to look it up right now. But know that this one stats pretty much across party lines. Democrats all voted for it, the Republicans all voted against it. So you can imagine that that's exactly where party lines that align. So if you're representatives and senators, Republicans, or if they're Democrats, you know exactly kind of where they voted on these bills. And then last one here, the last claim here, before we just kind of get into overall perspective, from my perspective as a conservative, election fraud hurts children, and so does demonic OSPI, and Washington OSPI director Chris Reykdal is Satan. So this is purely opinion. Chris Reykdal is no good for the OSPI office. He is a no good OSPI superintendent. That's my opinion. I think he's terrible. I think he's terrible for our state. I think he's going to risk us losing our federal funding, and really hurt our kids a lot. And I'll say less there. But Chris Reykdal, if you ever heard this for whatever reason, you are more than welcome on the podcast at any time. I would love for you to come on and defend these positions. You won't, but yeah, there is nothing that lists Chris Reykdal as Satan or illegal or demonic behavior. However, the things that he is doing from the OSPI office, the power that he's going to have, it's dangerous. It's a dangerous level of power for the OSPI office. So let's talk concerns. There's so many concerns, right? There's so many things I just went over, so many claims. Some of them true, mostly misleading, partial truth, right? It's important not to get charged up about all these things, right? Know the facts, do some research, take 30 minutes, go do some research, learn about these things, research this podcast, share it with others. I think I'm the only one that's broken it down in this much detail, things like that, different claims, whatnot, that are viral, just to help bring some clarity to this. Is this still a bad bill? Yes. Are these still dangerous for our schools? Yes. Is it dangerous for our children? Yes. Does it allow OSPI teachers too much protection to our power? Yes. So those are some of the concerns. The new enforcement powers given to OSPI, dangerous. Giving a state agency broad control over local schools, that's not right. That's not right. OSPI shouldn't have end all be all. We should be able to push back and take legal action, but now it's just going to go through a complaint process. So if you really have a problem, something really happens, just go and file a complaint. Go and file a complaint. We'll see if they listen. Anyone can file a complaint now. Community members, parents, students, anyone. Even if you don't got skin in the game, if you're just a diehard leftist advocate for anything that the left says, left is never wrong, then you can also file complaints and go hard after these things. Student privacy policies may reduce parental awareness on sensitive issues. Again, there is less notification on certain things. You may not know. You still have access to records and whatnot through other laws, HIPAA, FERPA, to be able to access. As long as the youth is under 13, you can access them as you want. I believe it's also, well, depending on what it is, you have access till they're 18 and some things. Just remember, you are the primary stakeholder of your kid's life. Repeal the notification rules. These do limit transparency about school-based services. And of course, the emergency clause, block public referendum, raising questions about democratic process. Because what is our democracy if we don't get to push back and challenge these things if we want to? Everything should be able to be pushed back referendum, whether it's a Republican bill, Democrat bill, whether it's about schools, taxes, public safety, whatever it is. It should all be able to push back. It should all be able to have referendum filed against it. Curriculum access remains protected. That's really important to know here. That's really, really important to know. School choice and opt-out rights are untouched, so you still have choice. Opt-out rights are untouched. No new ideology or curriculum content is required by law. Those are passed on separate laws, right? There was that bill that is going to force all districts by 2025 to accept a LGBTQ plus historical curriculum. However, there are loopholes in that. There are districts doing different things to keep that out of schools for the time being, and that they may have adopted all they needed to for the next couple of years. So remember, this is less about what you teach and more about how schools must operate under OSPI's watch. And I think with under OSPI watch, this is just dangerous. This is just dangerous. I can't reiterate this enough. OSPI being in control of this, Chris Reckdal being in control of all these schools, their funding and being able to, the power of his mallet, the swipe of his pen, as you will, if you know, you know. The power that he has is rather unchecked and rather dangerous for our children. What can you do as parents? Well, you can still inspect all curriculum and lesson plans. You can opt out of sex ed and surveys. You can be notified of law enforcement activity or school removal. You still have access to all academic, disciplinary, and health records unless you're under investigation, which is very easy for a student to claim that they are, being abused and whatnot. So you don't have access until a court is mandating those records. You can contact OSPI to file complaints about district violations, but I don't love that. I wish that part would change. OSPI should not have this much power. That's the part that concerns me the most, is how much power OSPI has. And it's not good. It's not good for anyone. It's not good for the state. It's not good for the kids. It's not good for this process. If you want to have your voice heard, use the OSPI complaint process, but also call your reps, right? Call your reps. Push, push, push. Do everything we can. Support bills, support referendums, support initiatives. that, battle these things directly, and whatnot, helping everyone understand kind of exactly what these bills are and what they're not at the same time. And I hope you found that helpful as well today, kind of breaking down all these different parts. I promise you a Q&A, some of the Q&A details I want to get to as well. Is there anything else that you need to know? We talked about all that. We talked about how OSPI now has more control. So let's talk about that just a little bit more. So I just want you guys to understand. So this is true, major structural change. They now have explicit authority to investigate complaints from parents, students, or residents alleging willful noncompliance with state law and that's noncompliance with state law, which federal law trumps state law, but Chris Rectal's office thinks that the state law, their laws trump state law or federal law, which is really interesting here. Civil rights, non-discrimination, curriculum accuracy, inclusion, HIB policy failures, harassment, something bullying, improper restraint, isolation, student discipline, misuse. OSPI may withhold up to 20% of basic education funds, discipline superintendents through PSCB, SB, trigger recall procedures for school board members, which I feel like they'll do a lot of recalls. I'm sure are in the not too distant future. And what is my cat doing? Something. This is a podcast, Kitty. She appearances every now and then. Let's see. So it's just really OSPI just has more reach, more oversight, which is really dangerous when it comes to state curriculum and whatnot. Let's see. Let's clarify school district roles, especially regarding gender inclusive practices, discipline, and student safety. So this is absolutely true. Several new mandates, gender inclusive practices. They must have updated the gender inclusive policy aligned with the OSPI guidance. Again, this is going directly against federal law. So OSPI is really going to after, they're fighting the wrong side of these 80-20 battles. They should be fighting, the battles instead of trying to keep parents out of school. How can we work with parents to increase our test scores and increase our engagement, increase attendance? Why are people leaving public schools? Things like that. How are we spending so much? What's not working versus, fighting these 80-20 issues on the wrong side of the 80-20. So it's rather sad to see those things. What else? Again, we talked about how it changes some language to more gender inclusive language, things like that. And again, both the House Bill 1296 and the Bill 5181 were explicitly designed to clean up, revise, and align older conflicting statutes with newer rights codified in Initiative 2081, which is now laws RCW A.604. So again, I mean, I think it's just interesting. I don't love that, Republicans kind of told to shut up, sit down. We're going to vote anyway, so shut up. It doesn't matter. I don't love this. I don't love that it has this emergency clause. I think it's just really, really bad. The language in these bills is pretty newly defined school policy language, OSPI authority, student protections, curriculum. All those things are different areas now. I don't know if we talked about the legal context, but um, this is just going back to RCW 28642, Title 9, WAC 392-190-060, OSPI rule. There's a lot of elements to this. I'm just trying to go through and make sure I get everything I can for you here. How they compare to OSPI guidelines, I guess we didn't really touch on that too much. Gender inclusion policy in schools, encouraged via model policies, required for all districts now under these two bills. Parental notification on gender identity changes not required by OSPI, still not required in law. Staff training encouraged mandatory via OSPI developed training, according to House Bill 1296. Complaint resolution handled at local level, now escalated to OSPI with enforcement power, and legal weight guidance level now codified in law with sanctions and not for non-compliance. So lots of language updates, lots of technicalities, lots of really honestly boring stuff that doesn't make sense to the average person. Again, I do have a Q&A. I'll post that in the show notes. Make this the easiest thing for you to kind of look at to be able to answer for yourself. Again, you can make your voice heard, call your reps, talk to people, push your school board to rebel, file complaints, find loopholes, find every loophole that you can. If you're a lawyer, join the fight. If you're a parent, join the fight. Don't sit idly by on these bills. Contact your reps, go to ledge.wa.gov, type in these numbers that I told you, make comment, contact your reps. Very, very important here. Still intact, like I said. Parental rights, opt-out rights, notification for crimes. Now changed. No advance notice for non-emergency school-based medical services. Legal resources replaced by OSPI oversight, and OSPI now has enforcement and funding control authority. So again, the OSPI control of this is probably the most dangerous and concerning part for me personally, because what are they going to do with all that power? What is Chris Reckdahl going to do while he's making supercalifragilisticexpialidocious terrible Trump signs instead of spending his time, money, and energy and actually fixing Washington schools and actually fixing the problems that we have in our state, helping our students, helping our middle school students, read above a third grade level, helping them get above a fourth, fifth grade level in math, helping them actually be successful, helping them actually set up for long-term success in their career field. as they leave transition high school. As they continue to just get pushed along, say, oh, okay, good enough, you got enough credits, go ahead and go move on to the next year. We're not going to deal with you. We're not going to hold you back because we can't helping educators feel wanted and needed and respected for their careers, for their passion that they have here. That's what Chris Rector should be doing, but he's not. And it's dangerous that he's gonna have even more power now to not do those things and to fight the wrong side of these 80-20s, these 90-10 issues, fight for the 10, not for the 90, and do what he feels he wants to do with his unchecked power now, which is dangerous, very, very dangerous. So with that, parental rights aren't gone, but the rules of the game just changed. These bills may not be as extreme as headlines claim, but they're definitely hand more control to Olympia, to OSPI, whatnot. So keep reading, keep asking, keep showing up. That's what matters. See you next time right here on the Evergreen Report. Make sure to follow Evergreen RPT on Instagram and X for real-time legislation analysis. Always DM your thoughts, stories, and local school questions. We want to hear from you.